Good morning. Happy Sunday. I have some responses from people who initially brought up Jessop versus City of Fresno, so I figured I would give some responses to them. And Michelle brought it up, and I'm going to call this Joseph. I'm going to just say that's Joseph Snable. That really irritates me. That Joe SFPH. I don't know. It's so close. I mean, if that is your first name, if your first name is Joseph, then either you can't spell and you mistyped it, or your parents couldn't spell and they miswrote it on your birth certificate, because that's weird. Anyway, here's Michelle. I did give a flippant response, but I'll give a slightly more substantive response to it. The infamous words clearly established. It's a freaking joke. I suggest you talk to some attorneys who litigate this kind of stuff, and they will tell you their problems with it. The issue with this is that I don't believe Michelle is aware that there are two attorneys typically on any civil litigation. There is the plaintiff's attorney, who's going to want things to be easier for the plaintiff, and then there's the defense attorney, who's going to typically want things to be easier for the defense. And plaintiffs will always kvetch about how hard it is to win, and defendants will also kvetch about how hard it is to win. And at the end of the day, if you only look at the attorneys who are the plaintiff's attorneys, you're going to get a lopsided view of the situation. Um, I I try very hard to give a neutral perspective on it. I realize my bias that I am a plaintiff's attorney. I have only represented defendants in civil litigations twice. So, you know, I do prefer it when things are easier for the plaintiff. That being said, there is a reason why these things exist. And instead of trying to convince me to go talk to plaintiff's attorneys, how about you try to come to grips with what I just went through with Jessop, with the clear flaws in Jessop that exist. I don't I don't like Derek Kumagai, and I don't think that he should be protected, except, I mean, because he's a corrupt cop, and nobody likes corrupt cops. But the law is the law, and the rules, and the reason why they exist in the form that they do is to protect the integrity of the system. And qualified immunity has a place. It, like I said, it weeds out the loser cases. Jessop is a loser case. And it clears the courts. It keeps the courts from getting cluttered with loser cases. It protects the defendant from having to defend a loser case. It protects the court from having to host a loser case. So then here's Joseph. And again, Joseph, if I'm mischaracterizing how you pronounce your name, I do apologize. I'm not intending to be flippant. First, Joseph provides copy pasta from the Cato Institute's website. Yet the Ninth Circuit granted the officers qualified immunity, comma, noting. Yet the Ninth Circuit granted the officers qualified immunity, comma, noting that the theft, and then in brackets of, the theft in brackets of, copy paste. It is a sentence that presumes the sentence before it exists. That's why it starts off with yet. And you only gave me one sentence out of a paragraph, so I don't know exactly what you're trying to say with that. It is also a misstatement of the holding. The officers could be sued for theft. They definitely could be sued for theft. This is the California Civil Instructions, the 2021 version. This is a suit, a tort that you could bring called conversion, which is not based on the Constitution. The plaintiff claims that the defendant wrongfully exercised control over the plaintiff's personal property. To establish this claim, the plaintiff must prove all the following: that plaintiff owned money, in this case. You have to prove the existence of the money and the plaintiff owned it. That the defendant substantially interfered with plaintiff's property by knowingly or intentionally refusing to return the money after plaintiff demanded its return. Plaintiff did not consent, plaintiff was harmed, and defendant's conduct was a substantial factor in causing plaintiff's harm. This is not subject to qualified immunity. So they could have sued under this. And like I said in the video, or at least I hope I said in the live stream video that I did, the plaintiffs, Jessop and Ashtian, filed a claim with California. According to the Governmental Claims Act of California, you have to first, before you sue California or a government agency or an employee of a government agency who is acting in the scope of their duties, you have to submit a claim. If California rejects the claim, or if the agency rejects the claim, then you have 6 months to sue. And Jessop didn't do that. And this Ninth Circuit opinion does nothing to say that you can't sue cops. You just have to do it within the bounds, within the statutory framework. So it's a misleading sentence, and you could see how Cato Institute is Mr. Swikert tried very hard to charge this particular website. I'm assuming to get donations or something. Where do they get their money from? Oh, ways to give. There you go. You could see where they do it. Like during the search, the officer seized an exorbitant $151,000 in cash and another $125,000 in rare coins. Just looking at that sentence, you could see how they're trying to spin things. First of all, why is it exorbitant? The warrant said they could seize all the monies. It didn't matter if they're $151, $151,000, $151 million. None of that mattered. They were the language of the warrant allowed the officers to seize all of the money. And it wasn't established that the officer seized $151,000. It wasn't established that they seized. This is another thing. Where is this $125,000 in rare coins? It's alleged the officers took rare coins. It's alleged the coins were valued at $125,000. But the plaintiffs never produced receipts. They didn't have receipts. They couldn't produce receipts. They never produced any valuation. They never had these rare coins valued by like a professional. You take it to somebody like, how much is this coin set worth? And the guy puts on his little jeweler's glass and he looks for scratches and he determines when they were made and what proof they are, how much gold is in them or how much silver is in them. And then he'll tell you, this coin was sold at auction. It's very similar for, this amount of money. So this coin, I think, is worth about that same amount of money. They never did that. You have to literally prove in court the value of the thing that you're taking in order for the court to give you money. And if you can't prove it, I'm missing my rare coins. Well, how much were they worth? I don't know. Then what? So it's just the Cato Institute, they wanted to file an amicus brief, or maybe they did file an amicus brief when Jessop versus City of Fresno petitioned for writ with the Supreme Court. Now, they were denied writ, but that's where they're at. So then he goes on to say the facts are not disputed. They took their property without any crime. They took their property without any crime. First of all, even Cato Institute does not does not say that there was no crime. So they were owners of a business. They owned a dozen coin pusher machines that operated very. So there you go. Even Cato Institute says that, there you go. They had these things, and they are games of chance. And games of chance, you can't manufacture, own, or possess them. Deals, plays, carry on, opens or causes to be opened or conducts as an owner employee, blah, blah, blah. Under his possession or control, or permits to be placed, maintained, or kept. I mean, there's at least 3 statutes in the California Penal Code that are violated. These are statutes against gaming. So yeah, and this was filed by the attorneys for the plaintiffs. These are all of the depositions, and we're going to look at the deposition of Ashton and Jessop. Let's get down to the defendants acknowledge. I guess I'll show it to you. Let's go down to like 100. Sorry, insert witty repartee in here while I'm looking for. Here we go. So I'm going to ask similar questions, blah, blah, blah. When did you first start getting involved in coin pusher machines? Sometime around 2011. I don't remember the month. They saw them. They looked into them. The coin pusher started going missing, and they looked into it, and blah, blah, blah. So then they also entered into a second meeting contract. Here we go. Hold on a second. So they entered into a contract with the city of Fresno. This is still Ashton. This is a deposition of Britton Ashton. This is a plaintiff. He entered into a contract with the city of Fresno. These are initials, yes. Initials, yes. Did he sign the second page as well as the third page? Yes. He got legal advice before he entered it. Yeah. He entered the contract, and he was identifying people and machines and stuff, and he was basically acting as a snitch. And you realize and understand when you entered into this contract that if you successfully completed the contract, you agreed to allow $50,000 to be forfeited to the city of Fresno, correct? I do. So he had agreed to allow he forfeited $50,000 to the city of Fresno. He did. And then, let's see, down around here. I need where they break and come back. Hold on a second. Witty repartee. I think they have to go. And here we go. They come back. All right. And then right quick, they enter into discussions on thought I was right in here. I was close. All right. So he also agreed to personally forfeit $50,000 as part of the contract. So there you go. They took their property without any crime. They seized property. There was a crime. Uh, in lieu of charges, they agreed to work basically as snitches for the city of Fresno, and they each agreed. They each agreed to forfeit $50,000. So there you go. They stole money, but the court could not find a case similar that could meet the second test of QI. They stole money. Well, see, it's never really been established. It's alleged that the officers stole money, but it's not. It's nowhere in here is it proven. The Jessop didn't see it happen. Ashton didn't see it happen. They can show they show, according to their accounting records, that they should have X amount of money, but they only had $50,000 seized, and they should have had $131,000, but they don't know when that money went missing. So, yeah, we don't know who, if anybody, took it. The city denies they took any money above $50K, which they did. Again, that's just an allegation. That's just an assertion. By the way, I've never done jaywalking law, so... and they were never charged with a crime again, but we have established that they admit they committed the crimes, and in lieu of being charged, they entered into a contract with the city where they each forfeited $50,000 to the city, and they agreed to provide evidence against other people who were operating these machines. Are you a lunatic lawyer? Yes, I probably am. Dummy, they stole the money. That's not in question. That is in question, because you have to remember that initially, Ashton and Jessop submitted a claim with the state of California, and the state of California rejected the claim. Now, you're going to say, well, of course the state of California rejected the claim. Well, think about this for a minute. The state of California, or the department, or whoever, doesn't want to spend a bunch of money on bullcrap. So, for example, with the laptop broke, and so the state of California or the agency or whoever handled the claim, they accepted the claim for the laptop, and they paid out $1,000. Because as an attorney, one of the jobs of an attorney is to look at, if you're going to be a defense attorney, someone brings in, okay, this is what they're saying. You look at it, you look at the demand letter, you look at what they're alleging, etc. And you say, well, we don't have a very good chance of winning on this, or we have a great chance of win, or whatever. But let's say we don't have a good chance of winning on it. Let's settle this. Let's offer them something. Let's take care of this, because it's going to cost more for me to go to trial, and we may lose even more than we're expecting. So let's put a known figure out there. That's why with a lot of the auditors, that's why they get settlements. It's because these cities, these police departments, these counties, whatever, they're saying, you know what, it's our potential liability exceeds that, and there are going to be known costs whether we win or lose in defending it. So why don't we just pay them some go away money? So it definitely is in question. If there was no question on the money being stolen, then number one, the cops would be arrested, because theft is still a crime. And number two, the state of California would have paid the claim. And number three, they probably... Think about this for a minute. Why didn't Jessop and Ashton, after California or the department rejected their claim for the $131,000, why did they then not sue? Because again, there is a cause of action for conversion. So why didn't they sue under conversion? This is state law. This This has nothing to do with the Constitution, so they could sue in state court for that matter. And there's no qualified immunity. So I don't get your point. And I'm out of my mind. So I hope I have answered the questions. If I have not, let me know. If you believe that I missed something, the attorney could also file the tort claim for conversion, separate and apart from any constitutional claim. Could have, but again, I don't know if you saw in the video. I don't know if I covered it in the video. After you submit your claim, your Governmental Claims Act claim to the state or to the department, if they reject it, you have 6 months from the date of rejection to file your lawsuit. 6 months, and the claim was put in 2013, and so they didn't, for whatever reason, they didn't file within that 6 month time frame. So, yeah. And the court can allow leave to amend the claim, but again, that claim is time barred. So there you go. Anyway, that's all. Thanks for watching. Have a great day.